Let's call the meeting to order. I think we've got two witnesses for this bill, and for the first witness, if people come in later, maybe they can get their questions answered by the second witness. To open us up, I would Representative Hill, would you mind opening us up with a word of prayer before we get started? Thank you.
Dear Lord, thank you very much for having the opportunity for us to come together to work your business, the people's business, and the state's business today. Give us wisdom and guidance in our proceedings so that we might do the best for all. And dear Lord, let us remember the men and women of the National Guard that we honored today and the families of those that have fallen to give us the freedom to meet as we are today. In that name we pray. Amen.
Thank you, Chairman. We're going to go first with House Bill 898, substitute to House Bill 898. And Chairman Earhart, are you ready?
I'm ready.
Okay, we'll proceed, sir.
Thank you, Mr. Chairman, members of the committee. The substitute to House Bill 898 you should have. I'll attempt to struggle through the very interesting language of this bill. This bill is a proposition that will allow merchant acquirer limited purposes banks. This is modern day banking, and there's a definition in there for you to read. A merchant acquiring bank is one, and again, banking is different today. We're talking about credit cards and credit card processing and networks and those types of things. So some of the terminology is interesting, but a merchant acquiring activity means transactions with payment card networks. It means providing the means to authorize valid credit card transactions. It means facilitating the clearing and the settlement of those transactions. Just those types of activities. And what this does, these are not regular retail banks. This is in no way, shape, or form your retail community bank or even your large multi-state bank. The only deposits they take are from themselves. They'll have no customers other than themselves. They will not make payments on deposits to third parties. They'll not engage in any of the normal traditional banking activities. What they must do is be engaged for the sole purpose of merchant acquiring activities. Those are that definition I just read to you. It's credit card processing activities, those types of things. They can have no fewer than 50 employees. They have to be approved by the Georgia Department of Banking and Finance, and it's my understanding that the department, I know they're here, has no issues with this. And they have to have sufficient capital that's adequate in relation to the amount of business it conducts, very much like a regular banking charter. And what this does is it creates and allows the charters for these types of banks. And one thing I really like, they have to pay for the cost of an application of their own regulation. So this will allow merchant acquirer payment processors to establish banks for the sole purpose, and that's critical, of electronically moving these payments through the card payment systems without having to contract outside with other types of banking institutions. And this will hopefully bring several of these 50 employee plus organizations to the state of Georgia, and we'll go through the process. It's fairly detailed in here. You can see that the Georgia Department of Banking has a significant oversight role here to make sure that these are chartered and eligible to do business in our state. Mr. Chairman, that's effectively what this does. I'll be glad to answer any questions. I know Mr. Pete Robinson is also here, who has some of the legal knowledge of what these types of merchant acquiring banks would do.
Thank you, Mr. Chairman. We'll give it a shot. That was. Does anybody have any questions for Chairman Earhart?
Quick question, Mr. Chairman.
Okay. What's your number?
Chairman Earhart, just line 32, limiting this to buying institutions that employ at least 250 persons residing in this state. What's the purpose of having such a large number of employees as qualification for being able to conduct business in Georgia?
My understanding is that's a fairly reasonable size for one of these particular institutions, and it's just not a.
But I guess just from looking at it from a small business perspective, that if it's if their ability to conduct business in a safe, sound, and effective manner and satisfy the State Department of Banking and Finance, why would we as a legislature mandate the number of people that would be employed by that firm, either at a minimum level or a cap on that number of employees?
My only ability to answer that is that standard statutory language with these, and where they're chartered in other states. This seems to have been something that works. If I know that the department has vetted this bill, I wouldn't want to speak for them, but that may be one of their requirements with respect to that. But that's not a specific I can give you a clear answer on.
Thank you, Mr. Chairman.
That was a good question. Are there any other questions for Chairman Earhart? None. Do it. What? Push it. No.
Thank you, Mr. Chairman. Chairman Earhart, and I may have missed this when you're. Has this been done in other states? This been set up in other states? Or is this a?
My understanding is that other states have similar charters that are available for merchant acquirers. This
There
is
are
much
charters
like
available,
what we're
but
trying to do is attract these types of banks to the
Right.
state of Georgia.
Right.
Much like we could or should have done maybe with Aflac, and we
Right.
want to make sure that it is the kind of thing we need to set up the business environment in Georgia so we can attract these types of institutions.
And that's really the objective, is to make sure we have an environment where we can have a huge employer come in.
Right. And as you know, we have several of these type transaction credit card processing companies in Georgia. We
Yeah,
don't
we do.
want them to go to a state
Right. I believe we got
like
one down.
Nebraska or somewhere that.
Yeah, we got one down in Macon area.
Yes, I
we
think
sure
you
don't
do.
want to lose. So yeah, okay. Good.
That's exactly what it's for.
Yeah, good. Okay, good.
Thank you. Any other questions for Chairman Earhart? Mr. Chairman, I know you have another committee that
Thank
you
you very
have to
much.
preside over. Thank you for coming and taking the time to make that effort.
Thank you, Mr. Chairman, members of the committee. I appreciate your time this afternoon.
We'll let you know how you did.
Thank you.
I think we had one person who wanted to testify. Mr. Robinson, didn't you sign up to speak for the bill?
I'd like to say just a few minutes, and I'll try. I know you've got a lot on the agenda, but I'll
Tell everybody who you are for anybody who hadn't been around for the last 20 years. I think we do, Mr. Chairman. I think we have a quorum. Yeah. Okay. Yes. Thank you.
Mr. Chairman, my name is Pete Robinson, and I represent a couple of parties that are interested in the establishment of this type of financial institution. One is Global Payments, which is a publicly traded transaction processing company headquartered in Sandy Springs. The other is Total System Services, which is a publicly traded transaction processing company headquartered in Columbus, Georgia. There are other payment processing companies with significant interests in Georgia, and Georgia has kind of become one of the real leader states in the processing business. There are several kinds of credit card transaction processing. This bill focuses solely on what is known as merchant acquiring processing, and it's the merchant side of the transaction when you swipe your card at the merchant. The merchant's relationship with an acquiring bank through the system, where they sort out what card it goes to, what bank issued the card, the amount of money that goes in, and it goes on through the network system. This deals solely with the merchant acquiring side, and I'm going to tell you that there are two stages of that flow through the Visa and MasterCard networks. One is the approval, the authorization stage of a credit card purchase, and the other is the what's known as the clearing and settlement, the payment side of it. One flows up to get authorized, and then it flows the money back down to pay the merchant for the goods. In order to participate in this system, the companies like Global Payments, Total System Services, First Data, which is headquartered here, and several other, another has a major presence here, two or three others actually. Companies like Payment Tech, and there are a lot in the business. about 80% of all the transactions on the merchant side are approved or authorized out of Georgia around the world. And it's a significant business. It employs thousands and thousands of Georgians, and is significant to the Macon economy, to the Sandy Springs economy, to the Atlanta economy, to the Columbus economy, and in other pockets around the state. In order to participate, there are 5 major players in a transaction, and it's the network, which is Visa or MasterCard. This doesn't really involve them a lot. There is the merchant who sells the product. It doesn't really involve them a lot. There's the merchant acquirer who takes that merchant information, and that's where this hits the system. The merchant acquirer under network rules is required to be a licensed, regulated financial institution. Now, Total System is not, Global Payments is not, First Data is not. So in order for them to participate, they have to contract with a financial institution. And I'm just going to say very quickly, and this is extremely complicated stuff, and I realize that, but this special purpose bank has not been done around the country. The chairman had it slightly confused with non-deposit, non-insured banks, which is a retail bank which exists in Massachusetts, Maine, Vermont, Connecticut, Maryland, and New Hampshire. So those are full-service retail banks. When we looked at this concept, in order for, say, Global Payments to participate with their network of transaction processing, they have to rent bin space in a licensed financial institution. And they rent space from Hong Kong Shanghai Bank, HSBC, or Comerica Bank up in the Midwest. These are they don't deal with First Community Bank of Columbus or somewhere. These are large financial institutions, very large, and they rent space to do that. This bill would allow those type companies to allow a charter to exist in the state of Georgia to become a financial institution solely for the purposes of participating in the flow of the transaction, not lending money, not like traditional banks lending money, not taking deposits from individuals or businesses, not honoring checks on deposits, not issuing credit cards, just to be a part of that transaction, the bin where you are in the acquiring space in that network transaction. Instead of having to rent space from Comerica in the Midwest, you do it in, say, Global Payment Bank. This sets up it very clearly outlines what merchant acquiring business is. And if you'll look over on page, I think it's page 8, it tells that if you look at page 8, line 240, it shows the limitations that this is a special charter that can't be used for anything else. It doesn't allow somebody to come in and compete with the traditional down-home bank or SunTrust or even a big bank. It just doesn't allow that. It says a merchant acquirer limited purpose bank may only accept deposits from a corporation or LLC or partnership or other entity that owns a majority of the shares of the merchant acquirer limited purpose bank. It can only accept deposits from itself. So there's no consumer to protect. There's no one that's going to be dependent on that deposit coming back to them. It further narrows it down. It says a merchant acquirer limited purpose bank shall not operate in a manner that attracts depositors from the general public, and no deposit may be withdrawn by the depositor by check or similar means for payment to third parties or other people. A merchant acquirer limited purpose bank may not accept brokered deposits from external brokers, or not. Well, I think that's always been non-core depositors. The only core depositor is going to be the owner of the bank, the shareholder. And it says they it goes on to say it shall conduct its deposit-taking activities only from a single location, only from the office in which they operate the merchant acquiring business. It may apply to receive FDIC insurance and that's a requirement. To be eligible for FDIC insurance is a requirement of Visa and MasterCard to be a regulated financial institution in their networks. And then it closes it out by saying that notwithstanding A of this section, the business conducted by a merchant acquirer limited purpose bank shall be merchant acquiring activities, and they are defined back over as the Chairman Earhart said earlier. I think it's page 2, section 7, line 48. Merchant acquiring activities are the various activities that he explained throughout the system. You know, I saw a picture yesterday while I was working on something else, and it was a picture taken in 1927 of 7 men fishing, and they were at Dead Lakes, Georgia. They were fishing, and the odd thing about the picture was they all looked like Greg Morris, Chairman Morris. They were all wearing a 3-piece suit and a tie while they were sitting there fishing, and that was the way they dressed. Back then, these guys dressed to go fishing. Well, suits and ties are still around, but they're not always the same, used for the same attire they were back then. They're not. Life has changed and things have evolved, and I kind of look at our banking laws the same way. Technology and electronic transfer and transaction processing is such an integral part of the economy that it wasn't 10 years ago, much less 80 years ago. This gives a little flexibility to our banking code. It doesn't compete with Georgia banks. The people that we're renting, my clients are renting these bins from that for the transaction are Bank of America, Comerica, maybe Citi. I mean, they're the huge global banks. 55% of this business is done by J.P. Morgan, Chase, and Bank of America, I believe, globally. But it allows it to come under the purview of our state regulators. It doesn't, our state regulators will have to look at the soundness, they'll have to look at the safety, they'll have to look at the capital sufficiency. They're not required to issue a license or a charter. There was a question about the 250. I don't know what the magic number is, Representative Williamson, but it was a structural integrity of what kind of critical mass they have. I can tell you why the 50 number was put in, that each bank must have at least 50 employees, and that was an economic development and retention side, that we want to make sure that there is job growth and job retention in this state, and they don't migrate to another state like Vermont, Massachusetts, Maryland, Maine, Connecticut, or Vermont or New Hampshire. And I'm not, that's not something they want to do. These companies are here, and we want to create more companies here like this. I probably said too much, but
no. Are there any questions for Mr. Robinson from the committee?
Mr. Robinson, thank you.
No, I think I got Chairman Houston first. I think.
One quick question: do you have to have a certain amount of capital to start one of these banks?
Yes, well, the statutory minimum is $2 million. But it's also dependent on the department to determine the appropriate amount of capital above that. But that's the statutory minimum.
Okay, I just saw code section. I saw it, but I didn't know what that meant. $2 million. All right, thank you.
Oh. Representative Smith, I believe you had a question.
With respect to acquiring this limited purpose access, is there a fee structure set up?
No, sir. There is not. The fee structure, there would be no fee structure for, there may be a fee structure. There would be a wholly owned subsidiary of an existing processing company. So they probably wouldn't charge themselves more than a cost structure fee. I mean, I doubt they would, there wouldn't be a profit fee in there. And this fee would not be charged to other parties. It's the cost of operating the bank would be borne by the processing company. This does not get into the issue obviously in the credit card space, there's been some talk about interchange fees in the past. This does not get into regular setting fees for participation by a merchant or a consumer or whomever. This is pure operational of the transaction.
I see.
Now, right now they are paying fees to the big banks to rent bins, and it would help them. It would be a cost efficiency, just in all candor, it would be a cost efficiency for them. Hopefully, they probably wouldn't have me here if it wasn't, for the transaction processing companies. And it
Thank
would
you.
encourage them.
Is that Representative Williamson?
Thank you, Mr. Chairman. Mr. Robinson, and really for the edification of the members of the committee, this is not my field of expertise, so pardon me if I'm asking some questions that y'all might know the answers to. What I hear you saying is a lot of this is going to be pretty much computerized, correct? I mean,
it's all electronic transaction.
It's all electronic. I'm struggling to figure out why you would have to have 50 employees as a target number of employees in line 86. The merchant acquired limited purpose bank shall have within 1 year, and you said it was an economic development issue. Why again is the state going to mandate? I know we'd like to see that, but why are we going to put some arbitrary benchmark if it doesn't have anything to do with the safety of soundness or the ability to get FDIC insurance? Or
in our discussions, we felt like that we needed to have something to offer the state of Georgia and to put some skin in the game rather than just retention of existing business.
But what cost is this coming to the state of Georgia?
They're going to have people to operate this bank. I mean, it won't just be an electronic transfer that's done by no one. I mean, there'll be compliance for safety and soundness.
But wouldn't the applicable fees established by the State Department of Banking and Finance? It says to defray the cost. Is this going to be basically a backdoor additional? Does it require additional appropriations to the State Department of Banking and Finance?
And I probably can't speak to that, but I do know that the cost, the way that the statute is drawn, the cost of approval, due diligence, and oversight must be paid, will be set by the department, and must be paid to them.
Then I don't know why you'd have to have the 50 employee minimum in there.
We feel like that really is in the best interest of the state. It gives the state a reason an additional reason to be involved in setting up this. And this is a new type operation. I mean, Georgia has done a previous limited purpose, special type bank charter in the past for credit card issuing. And that's kind of where this idea sprung from. But they're two separate things. But we feel like you need to have, that in order to be doing it, you need to have jobs that are created and retained.
May I follow up with another quick question?
Yeah.
Just a follow-up question. How many special charter banks do you envision coming?
I would bet an educated guess, and please don't hold me to this, would be there would be 3 pretty fast. 3 applications pretty quickly. I know of one specifically. I know of one that would love to do it right now. I know of one that their interest is sufficient. They are watching carefully. And I know of one that said they think it's a very good idea, but they haven't committed. And I don't.
So there would be competition.
There'd be lots of competition, and that's just from the Georgia companies that are headquartered or have major presence. Those 3 are headquartered here. I don't know about the out-of-state companies that may migrate over.
Chairman Houston, I think you had another question.
In sort of response to his question on line 86, one thing I liked about the bill when you said 50 employees, that they had to have been within the state, and so many of us have been concerned about the outsourcing of jobs, and we appreciate you putting that in the state in here. Thank you.
Representative Frazier, is that your line?
Yes, sir. Thank you, Mr. Chairman. I apologize for being late. Several of us have 3 meetings at the same
Thank you
time.
for coming along.
I got your text.
Thank you.
I don't know anything about this bill, and I know I'm late, but is there a Tennessee Merchant Acquire Limited Purpose Bank or Alabama? Is there other states that have this already in place? And when I heard the special charter, I really didn't want to hear that word again today, those 2 words. And I sure hope this is not special charter bank. Can you just briefly give me a quick synopsis of what this bill does so I can make a choice on to either vote it up or down?
This allows the state to charter limited purpose banks, not full service retail commercial banks. Banks that are engaged only in the merchant acquiring business of a credit card transaction for the transfer and processing of credit card purchases, rather than taking deposits from the public, rather than lending money to the public. It is allowing and Georgia has had on its books special purpose banks that, and by that it doesn't mean that it's special, it just means that it has a limited scope of operation. It is not something where deposits are taken, stock is bought, stock is issued, deposits are taken, loans are made, loans are foreclosed on. That whole big general banking, it is for the purpose only of participating in a credit card transaction on the merchant acquiring side, which is a special, which is a 1/5 or one of the 5 components of a credit card transaction.
Further question, Mr. Chairman? So this is not a physical bank. This is electronic, something that's going to be electronically done.
That's correct.
Okay, thank you.
I don't see anybody else's light.
Appropriate time, Mr. Chairman, I'd like
yes.
to make a motion.
Representative Peake, yes.
I move to pass on substitute to HB 898.
We have a motion to pass on substitute to House Bill 898. Is there a second to the motion? We have a second. Any further discussion? None. Okay. All those in favor of substitute to House Bill 898 will signify by saying aye. Aye. Those opposed will signify by saying no. The ayes have it. So substitute to House Bill 898 has been favorably reported out of the Banking Committee. Thank you, Mr. Robinson, for your time. Okay. Representative Teasley, are you ready for your 945 or 946? We got a quorum. You can start with either 945 or 946. That's your pleasure.
All right. Thank you, Mr. Chairman. And with your permission, could I bring up Mr. Braswell to
That'll be fine.
Department of Banking to sit with me and answer some of the more technical questions?
Okay. Thank you. That will save time.
All right. Yes, it will. I'm going to bring before you today House Bill 945 and 946. I'll go ahead and take those sequentially. And what I'm going to do is just basically give an overview of what these 2 bills do, and then let Mr. Braswell speak to some of the more technical points. In House Bill 945, in Section 1, you'll see it in lines 16 and 17. The proposed language would allow a bank to issue stock for less than par value under circumstances under the Department's approval. In Section 2, which starts in lines 26 and 27, it would allow a bank to petition the Department to allow a financial institution to pay dividends in certain cases where the bank's retained earnings may be negative, but the financial institution is recapitalized, or in other words, it's in good financial condition otherwise. So that's basically what House Bill 945 does. Do you want to deal with that one first?
Yeah, we'll deal with it first and vote on them separately. It's my understanding that they were separated because it was
right.
Legislative Council determined it's 2 subject matters that we would do. Okay.
I must admit, when the When I got the note from the Legislative Council, I couldn't help but think of my former delegation mate, Bobby Franklin, that he would have been proud to see this
Yeah, we followed
separated
the
into two different codes
Constitution.
because
Yeah,
it dealt
he'd
with
have
two
been
separate
proud.
matters.
Maybe it would be helpful, Commissioner, if you wouldn't mind just giving us a real-life circumstance in which these two changes would be applicable.
Sure. Thank you, Mr. Chairman. The first one regarding selling stock for less than par value. In this environment, there are times when, of course, banks are having difficulty in selling stock, and this would allow, the code currently does not allow a bank to sell stock for less than par value. That would be a last resort for an institution, but desperate times call for desperate measures, so this would allow a bank an opportunity to do that. The second one would allow a bank that has perhaps had significant losses over the last several years, which, as we know, many have had significant losses, but have recapitalized itself. And so they may have identified the safety and soundness concerns. They've written off the problem loans for the most part, have suffered losses, but however, they've been recapitalized, and now the banking department feels like they are have addressed their issues and are in a satisfactory, safe, and sound condition. This would allow that institution to pay dividends to their shareholders with the department's approval. We, of course, would want to make sure the bank is in a safe and sound condition before we would allow them to do that.
Good. My bank gets there. My address hadn't changed, so they send it to the same place. Okay. See, questions for Miss Chairman Houston, I think.
Two questions. When you went to buy this stock for below par value, would you be advised that you were, in your perspective, that it would be sold below par value?
An attorney would have to answer that, but I would assume it would be.
It would be written in the
known,
prospectus.
Yes.
That it was being sold below par value.
Yes.
The next question, when you pay dividends, we had a lot of banks that the federal government put, can't remember what the money was called.
TARP money.
TARP money.
Mm-hmm.
TARP money. Does that have to be repaid before you pay a dividend?
No, I don't. Well, we would.
So would these banks be able to pay a dividend before they paid the federal government back the money that they owed them?
It is not contingent upon that. No, it would not. That's a federal issue versus a state issue.
Well, it might be a federal issue against the state, but don't you consider the money that they got from the federal government when you're going by the soundness of the bank?
We would look at all factors, yes.
And so, how would it really be a profit if they still owed the federal government money?
But this wouldn't be a profit.
Okay, so dividends aren't usually based on profits?
They are, and that's what this is stating. A bank that is has been in an unprofitable situation, but has been recently recapitalized. It would allow, if everything had been addressed, them to petition or send an application to the banking department to ask to pay dividends. They would not necessarily be approved. We would have to look at all safety and soundness factors and then make a determination.
So it doesn't have any bearing on that they might still owe and have still owe the government?
We would look at all factors.
In other words, they're making a petition to the Department of Banking to allow this to happen. The Department of Banking would then have to make a judgment on whether that makes sense or not.
Currently, they cannot, under the current statute, they cannot make a petition and not make an application to the department to pay dividends, even though they're well capitalized and have identified their problems and perhaps may be in a
Well, let me ask this:
condition.
to clear, that would be somebody that didn't owe TARP money, does not have that option now.
Right. I would think that the idea of that being a TARP recipient would not be the case. No.
Well, I guess what I'm saying is I get your point.
You
what
get
you're
my
saying.
point.
I get your point. In what you're saying. I just want to make sure that we understand that if you haven't borrowed TARP money and you needed, for some reason, to give a dividend, if your capital ratio was over 10%, I don't know what you would say. I know in the case of a small bank, if you had people, there's always this concern of a bank, being solvent. If you're not on the board, you've got depositors and even shareholders out there who are always concerned. Nothing eases a concern like the mailing of a dividend check. And I'm assuming that, some of these folks would like to stabilize their community position. Am I misspeaking, or is that
That's right.
the reason
primary,
as I understood?
the primary institutions that would be addressed are the small community banks that have been recapitalized, that now it's going to take a while to grow their earnings back, but they have recapitalized and have addressed their problems and would like to pay a dividend to shareholders that haven't received any for several years.
Would they like to pay dividends on the money that they got to recapitalize on?
That's where the money would come from, yes.
Okay. Is that it, Chairman Houston? I think whoever 25 was, is that you, Representative Smith?
Yes.
Okay.
Thank you so much.
Proceed.
Thank you, Mr. Chair. With respect to what you just alluded to concerning the state of the economy and where we're at banking now, are there stringent timelines based on the strength of the stock market for the purchase of below par value options, or exactly what kind of timelines are we looking at? You said the banks are having problems. Is there a time frame on this, or is this open-ended?
This would not affect the current time frames. There's time frames already established, I think, in the law and the prospectus when one is sent out to issue stock, and this would not affect that whatsoever. This is just allowing the sale of stock for less than par value. Just a very simple change.
Yeah, thank you, Mr. Chairman. Just to clarify, Mr. Commissioner, as I understand it, first of all, to sort of address the TARP funds, if the money's not yet owed, if you're still performing under the agreement with the federal government on your TARP funds, then it's just like any other obligation you've got. If you're doing your part and the time of that part, the government doesn't have any problem with you, then you should be fine on that aspect of it. Am I correct on that?
That's
Mr.
correct.
Commissioner. Okay, on the other side, where there has been this necessary recapitalizations of these smaller banks, the investors that are coming in are going to be looking for a return on their money as quickly as possible. And you're not, believe me, as we're well aware of the State Department of Banking and Finance, unlike some of the other regulators that are out there, principally the federal regulators, or specifically the federal regulators, they're not going to let any distributions of profits go out of a bank that's going to affect the safety and soundness of that bank. But correct me if I'm wrong, Mr. Commissioner, a lot of the banks, these community banks, were organized as subchapter S corporations, and as such, those institutions are going to, the K-1s hit their shareholders, and they subsequently become responsible for federal and state taxes, irrespective of whether or not the bank pays any dividends. So you're not going to expect an investor to come in, buy $1 million worth of stock, then in a situation where the banks turn the corner, they are making profits, and then not be able to get anything back out and have an income tax liability with no cash to at least pay the federal or state taxes. Is that not correct?
That's absolutely right. That's correct.
So, at the proper time, I'd like to make the motion do pass.
There's one more question. I think Chairman
I'm
House.
just trying to understand it. I'm trying to having trouble wrapping my arms around it. What limits you for if the bank's making money? Why can't you just let them pay a dividend? Why do we have to pass a law to allow them to make a dividend? Pass a dividend they're off of cease and desist or whatever you call it. They're doing great. Why can't they just? Don't you have the right to let them make a dividend without us passing a law?
It's in the statute already as far as when they can pay a dividend and when they have to require.
What's the statute telling us?
It's, I believe, 7-1-411, I believe, is the one that references when a bank is eligible.
Well, can you tell me when a bank is eligible to pay a dividend?
Criteria must meet. Well, one of the things, like I say, it's quite a statute, and there's quite a list of things there. Like I say, and I'll be glad to provide that to you. Like I say, this does not lessen that, other than the fact that that statute would still stay in effect. But when they have been recapitalized in this current situation where they may have a negative retained earnings, but have been recapitalized where they would like to, like I say, those new shareholders would like to get a return on that money they've invested. We're looking at this as a means to perhaps help recapitalize some of our banks so they can attract much needed capital. It doesn't reduce the safety and soundness concerns because we still have us as the catch-all. Like I say, they have to ensure, we have to ensure they're in a safe and sound condition before we would allow that to happen.
I'm just trying to understand it. It's just.
Okay, Chairman? Okay. I don't see any more questions for House Bill 945. Chairman Burns.
Thank you, Mr. Chairman. This is one more tool in the toolbox, but I'm still having a little concern that we're asking a white knight or a number of white knights to come in, small investors, to recapitalize a bank, and then before it becomes profitable, they can start paying dividends. Just because it's properly capitalized, adequately capitalized. And that's what you're telling me.
I'm saying we would look at, regardless of who recapitalized it, we would, if they made an application, we would look at all factors. But, you know, sometimes that's the difference between life and death of an institution, is whether they can attract that capital. And so this is giving, like I say, another tool perhaps for banks to utilize to attract that capital.
Okay.
An existing shareholder may be in a decision to decide whether to dilute my shareholder value or to watch it go down to zero, which is unfortunately what many have had to do.
And you've seen this from the commission in other states. This is something that's helped provide some capital for banks, to save some banks.
I don't even know if that's available in other states. I don't know. As far as this component, I don't know.
Okay. Thank you, Mr. Chairman. Thank you, sir.
Who's 28? Representative Frazier.
Thank you, Mr. Chairman. Is this a bank saving bill?
It is something I think that would help attract capital to needed banks. We're looking at that as something that would do that. I think it would be rarely utilized, just in a small handful of cases. I think would that be where someone would be willing to sell the capital below par value. But it is, because you'd have to be in a desperate situation to want to do that. But I think it is something that is needed to allow the Department of Discretion to let a bank do that if it is needed between life and death of an institution.
Well, I'm a little concerned because the banks are the reason why we're in this mess we're in originally. And will this help my small banks in Burke County or Augusta having not to have to merge together to keep one bank running? Or will this help my bank sustainability if they do start having problems retaining resources and capital?
Perhaps if they were in a need to sell stock and they had a difficult time in attracting stock, it may very well help that institution.
Thank you.
Thank you. Chairman Houston.
One last question. Can banks now not sell stock below par value?
No, the statute does not allow
Does not allow it to sell.
Right.
Okay.
I would say one thing from observation, at least. I mean, the only thing worse than in selling below par value, the only thing worse than losing all of your investment and selling it to somebody else is losing all your money and going to a bank closure. And I think this is what we're hoping, that there might be for somebody somewhere the option that this might be avoidable.
That's right. This will not be a panacea. It's just
Right.
one thing that may help.
Okay. Representative Williamson, did you have?
I'd like to make a motion do pass.
Just the proper time. There's a motion do pass on House Bill 945. We have a second. Any further discussion? All those in favor say aye.
Aye.
All those opposed? The ayes have it. 945 is favorably reported.
I want to compliment Representative Teasley on the excellent presentation.
Yeah,
part
yeah.
Of the bill.
That's awfully gracious.
That was a slam dunk, Representative. You're doing a good job. All right, let's go to House Bill 946. Are you ready for that one, sir?
Yes, sir.
Proceed.
House Bill 946 deals with more of the mortgage side of the industry here, and in sections 1, 3, 5, and 6, they're largely just grammatical changes. I don't want to cite the lines for you. Basically, Grammatical changes have been made to replace the word transact business in the state to engage in activities. So it's more of a grammatical change than anything else. The more substantive part of the bill is going to be in Section 2 and Section 4. In Section 2, it's starting in line 64, going to 67, line 71, 99 to 101 and 106. This is rules. Language has been added here to the code section to include violations of the rules of conduct for test takers as developed by the Mortgage Testing and Education Board of the nationwide mortgage licensing system and registry in consideration of licensure. In addition, the clarifying language has been added in the instances of an applicant or licensee's criminal conviction, which language states that a pardoning authority need not be in the jurisdiction of the conviction so long as the disability of the conviction is removed in this state for the applicant. And then also there's been a change made that would allow the department the discretion with licensure after a cease and desist order has been issued. In Section 4, and I didn't write down the lines there, but in Section 4 it's been changed to clarify that a mortgage lender may continue to service mortgage loans for a period not to exceed 6 months after their license is no longer in place. In other words, they're trying to service a loan for somebody who's applied, and they're just trying to finish up their dealings as they're getting out of the business.
Okay. Does anybody have any questions of either of our witnesses? No questions on House Bill 946. Does anybody have a motion on House Bill 946? We have a motion do pass. Do we have a second? We have a second. Is there any further discussion on House Bill 946? Okay. All those in favor signify by saying aye. All those opposed, no. Okay. The ayes have it. House Bill 946 passed due favorably. Congratulations, Representative Teasley.
Thank you, Mr. Chairman.
Thank you, Commissioner. Thank you. And thank you, members, for coming over. I know everybody's busy. Thank you for getting us a quorum together. Thank you. We're adjourned.